Hello and welcome again to Perspectives on Closing Loopholes, one of a series of online offerings by Clayton Utz. We created this series to help you navigate the raft of recent industrial relations changes in Australia. We've brought together some of the most knowledgeable industrial minds in the country and want to provide you different perspectives of key stakeholders. We will discuss what the changes will mean to employers, employees and the participants in the industrial relations system. We've had a fantastic response to our guest to date. We kicked off the series with His Honour President Hatcher, President of the Fair Work Commission, and then heard from Professor Ron McCallum AO, leading legal academic, and Dr Graham Smith, one of the country's most sought-after employment lawyers. We were privileged to hear from preeminent industrial silk Frank Parry KC, as well as the perspectives and insights from Jessica Tinsley, the Director of Workplace Relations and General Counsel at the Australian Chamber of Commerce and Industry. Our listeners will have also most recently heard from Anna Booth, the Fair Work Ombudsman. If you've not seen them yet and you're interested, you can find them on the Clayton Utz website or wherever you access your podcasts from. I'm Matt Kelleher, a partner in the Clayton Utz Melbourne office, and the series presented on behalf of our National Workplace Relations Employment and Safety team is hosted by myself and my fellow partner, Shae McCartney. Before we start, I would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners and custodians of the land on which we meet today and acknowledge their connections to land, waters and seas. We recognise their ongoing strength and resilience and the important role they play as leaders in their communities. I pay my respects to elders past and present. Shae, I'll get you to introduce our special guest that we have with us today.
Thanks, Matt, and I'm very excited to introduce Steph Daveson. So today we're filming a special director's edition where we're going to talk about some specific aspects of closing the loopholes legislation and particularly how it will impact on company directors. So joining us today is our national practice group leader of the Corporate Mergers and Acquisitions and Capital Markets Group at Clayton Utz, Stephanie Daveson. Stephanie has over 30 years' experience and is sought out by board members and C-suite executives for her strategic and commercial insights. And I must say, I've had the benefit of some of them, in fact, many of them, and can attest to that. Stephanie has experience both as a director on listed and public boards and is a former member of the Takeovers panel. Stephanie's recent accolades include being named as the Capital Markets Lawyer of the Year Australia and recognised as peer-reviewed Best Lawyer in M&A since 2013. So very grateful. Thank you, Steph, for your time today. Can I start with asking you, Steph, you're regularly asked by boards and officers about how to discharge their obligations, and we're going to talk specifically about underpayments, but I thought it might be useful to just start with how does the company framework work and the director's obligations sit within that?
Thanks, Shae. The Corporations Act framework primarily regulates officers by imposing a set of duties on them, and they include duties to act with care and diligence and in good faith, to avoid conflicts of interest and not to misuse their position or information. So these duties are really the scaffolding on which the integrity and proper functioning of corporate governance in Australia is established. Of these, the duty that's the subject of most regulatory and class action activity and would be most relevant in the context of employment-related issues is the duty of care and diligence. Now, this requires that a director or any officer exercise their powers, discharge their duties with the degree of care and diligence that a reasonable person would exercise if they were in the same position and under the same circumstances. So that itself seems simple. But the duty is also subject to what we know as the business judgment rule. And that provides that an officer who makes a business judgment will meet the requirements of that duty if they act in good faith, they don't have a material personal interest in the matter, they inform themselves appropriately, and that's relevant, and rationally believe that the judgment is in the best interests of the corporation. So in the context of, say, a decision around wages, in order to enliven the business judgment rule, a board or officer would actually have to make a decision. And that rule will not be available to them should they not make a decision. I also just wanted to point out who an officer would include. So it's directors and secretaries of a company, but it's also individuals who participate in making decisions that affect the whole or a substantial part of the business or the corporation, or alternatively, if they have the capacity to significantly affect the corporation's financial standing. So it would often and usually include the CEO if they're not on the board. The CFO can include the General Counsel, Chief Operating Officers, Chief Technology Officers, for example. And just the definition does also extend to receivers, administrators and liquidators.
Thanks, Steph. Before we get into the Fair Work Act changes, can you talk just a little bit about how that Corporations Act obligations that we're just discussing might be enlivened in relation to underpayments issues?
Well, we have for a while and are currently in an environment where many well-resourced and sophisticated companies have uncovered wage underpayments, and there is clearly a heightened regulatory interest. So therefore, that all equates to risk for companies should underpayments be found. So in these circumstances, it is increasingly challenging and risky for officers to maintain a position where they haven't had any independent validation of their wages system and processes, to really dig into some of these, querying and challenging whether there are systemic underpayment issues. And this is because if an issue does arrive, I believe it's going to be very difficult to convince a regulator or a court that in the exercise of that duty of care and diligence, they should not have undertaken that exercise. I think officers and directors need to think very carefully about who they ask to do this exercise, whether it's done using internal resources or external resources. And the reason I say that is because in conducting that analysis, if you decide to use your internal team, you're effectively asking your team to admit to failings in the performance of their duties. They have to admit to an error, in essence. And, particularly if that error has the potential to expose the corporation and its officers, their bosses, to significant consequences. You'll be relying on the expertise of internal teams that have got it wrong, so to speak, and that's clearly challenging. So you're asking that team to admit to a mistake, exposing them to loss of employment, potentially jeopardising future employment opportunities for them. So that's an inherent conflict of interest in itself. So officers need to be cautious when considering who is best placed to undertake the analysis. If a significant issue does arise, you've also got to be aware that there can be solvency implications for the corporation, and we've seen that happen in the past, and that may also need to be considered.
And Steph, is that any different for a listed company? Like, for example, are there additional obligations for notification, for example, to the stock exchange?
Yeah, well, listed companies do have continuous disclosure obligations under the Corporations Act and the listing rules, and that will require them to notify the market operator, for example, the stock exchange, of information that a reasonable person would expect to have a material effect on the price or value of the company's securities. So depending on the extent of that underpayment, that could include notification related to the underpayment of wages, particularly if it could affect not only the financial performance, but in circumstances where it might materially impact the reputation of the organisation, that may need to be disclosed as well.
Steph, we're going to talk about criminalisation of wage theft. As you know, the Closing Loopholes legislation has introduced a new criminal offence for wage theft that will be regulated by the Fair Work Ombudsman and prosecuted by the Australian Federal Police and the Commonwealth Director of Public Prosecutions. These changes have commenced on the 1st of January this year. Under the new laws, employers will commit an offence if they intentionally underpay an employee and can face serious penalties. The penalties target both the corporate entity and an individual and can include significant maximums. Contravening individuals can face up to 10 years imprisonment if a court imposes a fine. So the introduction of the wage theft offence is a significant milestone in the workplace relations space, something we've never seen before. We're keen to hear your thoughts on how our corporate clients have been preparing and are ongoingly getting themselves prepared for these new wage theft laws. How are your clients responding, if at all? I mean, I'm sure they are, to the new wage theft laws, and have you seen a shift in culture or awareness across corporate entities as a result of these provisions?
Yeah, it's a really good question, but to be frank, I don't actually think, or I don't see that the new laws are impacting culture or awareness of this issue in any material way in the companies we act for, I don't see officers intentionally involved in underpaying wages. Now, clearly there are always individuals who act with either ignorance or disregard to the law, but in my experience, certainly for our clients, they're the exception rather than the rule. I mean, we've had the high-profile wage case, I think that was 7-Eleven back in 2015. Since then, that's wage theft has stepped in and out of the spotlight. It's gained increasing prominence. And in my experience, officers and boards of Australia's larger corporations have been alive to this issue for many years. And it's been top of mind, frankly, for some time now. So I don't personally believe that criminalising intentional underpayment has moved the dial in any material way. As far as I can determine, the actions that have been taken by regulators to date in this area are largely against smaller businesses and companies who have directors who also run the businesses and other shareholders. So they're effectively management and business, management and the board are one and the same people. I actually think the high degree of complexity in our wages regime in Australia results in significant difficulty in complying with the law, and my view is that this is the primary driver of wage underpayment.
You touched on the fact that you didn't think the wage criminalisation was really going to shift the dial too much. Are you seeing wage underpayments as a live issue amongst your clients on an ongoing basis?
Yeah, I think the risk of underpayment remains a live issue and something that's top of mind. There are some particular areas where I see practice has changed over the last few years and where the risk is greater. They're primarily in two areas. One is due diligence associated with acquisitions. Years ago, you wouldn't have seen a lot of thought given to wages, compliance and underpayment, and that is a very interrogated issue now in those sort of transactions, including by buyers and their insurance, if there is warranty indemnity insurance. And also when you're looking at listing on a stock exchange, I think part of that process will commonly now involve interrogating wage compliance.
Steph, what level of involvement or oversight are you seeing directors and boards have of workplace underpayment matters, given the reputational risk that they carry?
Oh, look, in my experience, boards are incredibly involved in those matters should they arise. Identified issues are usually quickly escalated to boards and they remain actively involved throughout the process, including in regulatory notifications.
In terms of compliance culture, how do you see boards and directors being able to improve that? And is it just boards and directors that you see as responsible for a compliance culture in this respect?
Yeah, it's a really good question, Matt. I mean, I said earlier that I believe a lot of the compliance failures, particularly in the larger organisations, are primarily rooted in just the complexity of our wages system rather than intentional failures to comply. And look, if you accept that, then I think a significant step to improving compliance is probably leveraging technology solutions. And that really improves compliance at the coalface rather than at the board level, whether that be in the way in which awards or enterprise agreements are interpreted to accurately tracking hours worked, for example, which seems to be a significant issue when I'm involved in due diligences with acquisitions. And what technology does is it can automate those sort of time tracking issues, ensure accurate payroll processing and improve reporting for the board. So I think a technology solution significantly reduces the risk of human error and provides a much higher degree of comfort for boards. The other area that I see that issues always seem to arise is employee classification and enterprise agreement interpretation. I'm not convinced that enterprise positions on those matters are best left in the hands of HR professionals. I do think a level of legal involvement to ensure correct establishment of rules would greatly assist in reducing the risk of inadvertent errors that then become systemic issues. In relation to who this needs to be driven by, well, the culture clearly is set by the board, but primarily is driven by management under oversight by the board. I've actually got a question for the two of you, if that's okay.
I don't know how this works.
In your most recent vodcast series, the Fair Work Ombudsman, Anna Booth, and I really enjoyed that vodcast, was interviewed, and she explained how the Fair Work Ombudsman is currently upskilling their investigators for the criminal jurisdiction. They're preparing for the commencement of the provisions. And they're also going to be receiving significant funding to investigate these issues, and they're going to take sort of sophisticated sectorial approaches, target specific industries. Given all of that, what do you think boards or directors, I mean, I'm interested in your views, what they need to start focusing on now in order to prepare themselves for this increase in regulatory firepower?
Yeah, well, I might jump in on that one. I think your comments earlier were so accurate in terms of no big corporate directors are going out, deliberately trying to break the law. Well, certainly none that I've met. So it really is a due diligence process, and like any due diligence process, you want to do it systematically, but you also want to do it in a documented way, and you want to do it with an understanding of your own organisation's risk and strategy. And so I think first thing is obviously the Fair Work Ombudsman's put out guidelines, understanding them and making sure that your governance strategy ticks off those guidelines is a great start. Understanding the risk appetite of the board as well. Different companies have really different compliance risks, and a small company might actually have very significant compliance risks, whereas, as you said, a large company that's got good sophisticated technical solutions may actually have quite a low risk, especially if they've got, very simple enterprise agreements or award positions. So, the board actually setting what do they want to be involved in, what do they want to get reported to them, what is their risk level that they, how far they want to put in control measures to manage that risk, just like they would with any other organisational risk. And then once they understand that, they can set their governance framework, which, should have some element of auditing and reporting back to the board that, so that they know that things are going consistent with the measures they set up. And then, of course, every, organisations change and they need that review process. So, whether it's once a year, whether it's once every 3 years, they go back and look at all those things again and make sure that their governance process is actually working consistent to them. The Fair Work Ombudsman's been very clear as well that, boards can and should rely on external advice. So getting advice to set that up, and then where there are tricky issues, getting external advice, it's appropriate to then rely on that advice. And I think if an officer has, assured themselves that that sort of process is in place, I would find it very difficult to see how they could be involved in it, even if there was an underpayment, any sort of allegation of wage theft, for example. Steph, that probably leads me on to, that knowingly involved issue. And this was another topic that was discussed with the Fair Work Ombudsman, and it concerned the accessorial liability of directors, which is where they can be liable for a civil penalty if they're knowingly involved or concerned in a contravention of the law. Obviously, these matters have significant penalties, and we've seen in recent times some very high-profile cases. So, Sushi Bay Outlets had a penalty of $1.6 million against the sole director. And there was also Blue Sky Kids Land, which was a $5 million court in penalties and specific orders against the two directors. Again, these are well understood schemes, and exactly as you said before, these are smaller companies, perhaps without the sophisticated structure that we're talking about. But Anna Booth has said, the Fair Work Ombudsman will always pursue accessorial liability where possible, and to quote her, because while companies are legal entities in their own right, the minds of companies are actually in the minds of people who manage and direct those companies. So she said she'll look at every case to look to see if there's accessorial liability. What do you have to say about that? Is a director ordinarily knowingly concerned in its company's involvement in a contravention?
Yeah, look, I think this is probably one of the most problematic areas from non-executive directors' perspective. I 100% agree with Anna's comments about the minds of company being the minds of the people who manage and direct those companies. What I do worry about is whether the role of non-executive directors is fully understood within particularly larger organisations. So if you take a small company where the board members are also management and also shareholders, I mean, it's simple, right? The mind of the company is the board because they are also management and they are also shareholders. So that's relatively straightforward. However, it gets more complex the larger the organisation becomes. And I think it is important that we, as a community really acknowledge that a non-executive board member is effectively a part-time role, right? It's management who are tasked with the day-to-day control over ensuring regulatory compliance. The CEO, the CFO, heads of HR, general counsels, they actually run the business on a day-to-day basis. So in my view, these are the people that are primarily responsible for ensuring wage compliance, whereas the board's responsible for setting wage compliance as a strategic priority. So if a company can demonstrate that the board has set wage compliance as a strategic priority, then they've really fulfilled their duty and they've checked in on that compliance. It's then a management failing should there be an underpayment. And it's management that should be looked to in relation to that in the first instance rather than necessarily directors.
Thanks, Steph. And I think that sort of raises that important point, which we often see in safety governance as well, which is that as a board member, you really do need to sort of stay in your lane. And if you start sort of stepping into the management of a company and you then may become knowingly involved with things that you're not actually in control of. And so, understanding the differentiation between management and governance, I think is absolutely critical. Thanks, Steph. I really enjoyed that conversation.
Thanks.
Definitely, Steph. Thanks very much for joining us today on this episode of Perspectives on Closing Loopholes. It was fantastic to hear the insights and planning that your corporate clients are having in response to the raft of recent industrial relations reforms. To our viewers, thanks very much for joining us on this episode of Perspectives on Closing Loopholes. We look forward to you joining us again soon.